But these are some frequently asked questions about so-called underground regulations here in the state of California. So first, is there actually a law in California regarding underground regulations? Yes, it's found in Title I of the CCR, the California Code of Regulations. And in Title I, there are a number of regulations under the purview of the Office of Administrative Law, OAL. Specifically, Chapter 2 of Title I is titled Underground Regulations. And OAL has 4 regulations on the topic of underground regulations. So first, what's an underground regulation? Well, in 1 CCR section 250A1, it actually defines an underground regulation. And it says that any guideline, criterion, bulletin, manual, instruction, order, standard of general application, or other rule, including a rule governing a state agency's procedure that is a regulation as defined in Government Code Section 11342.600, but has not been adopted as a regulation and filed with the Secretary of State pursuant to the APA, and is not subject to an express statutory exemption from adoption. That's what an underground regulation is. In other words, it is a regulation under the statutory definition, but it didn't go through and be adopted pursuant to the APA process. How does someone challenge a possible underground regulation? In 1 CCR section 260, it provides for the submission of a petition regarding an underground regulation. And Section 260 specifies that a written petition may be submitted to the Office of Administrative Law. And that written petition would allege that a state agency has issued, used, enforced, or attempted to enforce an underground regulation. And the written petition, of course, seeks such a determination from the OAL. What must a challenger file on a possible or alleged underground regulation? Again, it's a written petition that's submitted to OAL. The petitioner must provide that written petition and all of its attachments to the challenged agency, either prior to or concurrently with the petitioner submitting it to the Office of Administrative Law. Now, what must this written petition include? It requires under Section 260 of the CCR the following items to be included: the petitioner's contact information, the name of the challenged agency, a complete description of the challenge rule and a photocopy of that challenge rule, a description of the actions of the challenged agency showing that it has issued, used, enforced, or attempted to enforce this challenge rule, the legal basis for concluding that the guideline, criterion, bulletin, or provision is a regulation and that no express statutory exemption to the APA is applicable here. Information demonstrating that the petition raises an issue of considerable public importance. The petitioner's written confirmation that the petitioner submitted a copy of the petition and all the attachments to the challenged agency. And finally, the petitioner's written confirmation, including their contact information. What is done with a written petition filed to challenge a possible underground regulation? Well, 1 CCR section 270 concerns the review of petitions regarding underground regulations. And basically, the rule is that when OAL receives a written petition, it has to determine if the petition is complete, and that must be done within 60 calendar days of receipt. Now, what happens if the petition isn't complete? If that's the case, then OAL will notify the petitioner in writing what is missing from their petition, and OAL will begin the review period of when the petition is complete. What can OAL do with this written petition? OAL will either accept or decline to consider the petition, and OAL will inform the challenged agency that the petition is under review and offer to provide a copy of the petition. How long does OAL have to review that written petition? Within 60 days, OAL is required to determine whether or not to consider the petition on its merits and can do so in the entirety of the petition or just part of it. Are there factors that guide OAL in reviewing this written petition on underground regulations? Well, keep in mind that OAL has exclusive discretion to consider the petition, but in the California Code of Regulations, it includes a number of factors that OAL considers in deciding whether or not to accept a petition. Those factors include the degree to which the petition raises an issue of considerable public importance, whether the issue raised by the petition was or is currently being considered by a court or other body, whether the challenge rule is superseded, whether the challenge rule expired by its own terms, additional relevant information that's pertinent to potential resolution, the availability of OAL personnel to complete the review of the petition. What happens if OAL does not consider the petition? If OAL declines to consider the petition, then OAL is required to immediately advise the petitioner as well as the challenged agency of its decision. And OAL must specifically indicate that the decision in no way reflects on the merits of the underlying issue presented by that written petition. Now, what happens if OAL does consider the petition? If OAL decides to consider the petition on its merits, then they must issue either a summary disposition or a determination. What are some grounds for OAL to decide a rule is not an underground regulation? They include that the challenge rule is contained in a California statute, or the challenge rule is contained in a regulation that has been adopted pursuant to the APA, or that the challenge rule is statutorily exempt from the APA. What happens if OAL issues what's called a summary disposition? Then the written document must state the basis for concluding that the challenge rule is not an underground regulation. The summary disposition is filed with the Secretary of State, and it's sent to both the petitioner and the challenged agency within 60 calendar days. OAL also has to publish its summary disposition in what's called the California Regulatory Notice Register. Now, what happens if OAL issues a determination? Then OAL has to notify the petitioner as well as the challenged agency of its decision. It also publishes the petition in the next California Regulatory Notice Register, and it gives notice to the public that comments on issues raised by the petition may be submitted to OAL. Now, when must the public make any comments? Any public comments have to be submitted within 30 calendar days from the date of publication of the petition in the California Regulatory Notice Register. Can the agency provide comments? Yes, the challenged agency may also submit a response to the petition to OAL, and any response by the challenged agency is required to be submitted within 45 calendar days of the publication of the petition in the California Regulatory Notice Register. And finally, when must OAL make a decision? That has to occur within 120 calendar days. And here OAL issues a determination whether or not the challenged agency has issued, used, enforced, or attempted to enforce a so-called underground regulation that violates the APA.